All right, so reading Humphrey v. LeBlanc, that was decided in the U.S. District Courts, I think the Middle District Courts, just in September 2025. I had a lot of information to read. The reason I am pointing this case out is the recency, and because I started reading it in October, the next month, or at the end of September, I forget which exactly. But it was decided, I think, September 25th, so maybe more October. But I typed in BJG. All right. I was asking the guards if they were conforming with the American Correctional Association, I think the ACA. I think that was mentioned in a court case, and I asked the guards if they're conforming with that on the kiosk. I make messages to the guards, they respond. The ACA, the American Correctional Association, and they're like, no, the BJG. And I spelled out the American Correctional Association, but they didn't spell out BJG. So I had to ask them, what is BJG? And they, I don't know, female or male, I never know who's actually responded, who's read my stuff. I think some have given me hints. Hi Travis. When they come into the dorm, it's hi Travis. For some of them, which gives some kind of a hint. I don't know what exactly. But the BJG is Basic Jail Guidelines, which has been established for the guards to follow. It's supposed to it was created to train the guards to respect the inmates' civil rights. But I've asked a few guards if they know what the BJG is, if they know what the Basic Jail Guidelines is, and a lot of them don't even know. I even asked one as I was being released if she knew what it was, and she had no idea. So I don't know what's going on with that standard of training, but it doesn't seem to be resonating with the guards. But I used that BJG as my search on LexisNexis. Just curious, how many times, how has it been used as a reference in court cases, on Supreme Court cases. And, now that I think about it, I don't know how I got a hold of it, because if you only search on the state Supreme Court level, you won't find Humphrey v. LeBlanc, because that's a U.S. District Court level. So I had to have searched in the federal courts for BJG, which I must have done, because that's what came up. And I got Humphrey v. LeBlanc, which Humphrey is inmates. LeBlanc was a former secretary of the corrections, secretary of corrections, secretary of LDOC, so Louisiana Department of Corrections. They got sued on their own, by their own selves. Okay, not just suing the DOC. They're suing the actual person in charge of the LDOC, the secretary. The secretary has control over the entire state of the DOC, the Department of Corrections, and Safety, more just Department of Corrections. I think the sheriffs have more control over the safety. But I got all these notes, not in any good particular order, that I was writing off of the court case that I found interesting. It was at a time when I was done with the trial of serving my 270 days. I was in October. The release dates was back and forth from December 26th to December 8th, November 30th, back to December 8th, which I think, by calculation, I think it should have been November 4th, but for a hard calculation, if you just looked at raw time in jail, it should have been November 30th. But in theory, with a double conviction, it should have been November 4th. My release date should have been. it was in that period of time, October, where I was really reading while all the other inmates were asleep. In the morning time, they slept in till noon at least, 1 o'clock. I was getting on the kiosk and the tablets. We're only allowed 15 minutes tablet use every 3 hours, so I was timing that. Sometimes I'd get 4 uses in a day, but most of the time the kiosk would go down, so sometimes I would get zero times on the kiosk for the day. I'd have to spend some whole days not being able to read anything, just sit there and watch TV. And so that took away from my studies, all right, because the kiosk broke down. I'll tell you what though, L3 dorm, the kiosk never broke down. L3, for some reason, had some special magical powers in that kiosk where it just never broke down. But the other 2 dorms that I was in, L1 and L4, they broke down. And I tried to tell the tech support that, and Captain Glover brought him in one day, and I was going to say, I just want to tell the tech guy something, and Captain Glover is like, don't, you can't tell him nothing, all right? We're leaving. And so I couldn't say what I wanted to say. Captain Glover told me to shut up, pretty much. So I thought that was interesting. So I didn't get to read as much as I wanted to, get into depth. But that's why I take notes, so that I know that these kiosks go down. So I take notes, and then I can read them later. I originally stuck these with toothpaste to the wall, all right, but then Captain Glover and a higher ranking officer came, guard officer came in and told me to take them off of the wall. So I had pretty much all of these on the wall in various places. So I'd like to just sit down on my bunk and stare at these and reread them and read them over and over, trying to make sense of all this information from this case, the points that were being made. I put something more in the public area. All these were near my bed. One in particular I put more for public, and that mentioned specifically a quote from a judge talking about how it ended with 1 in 4 inmates are over-detained. And we had a room full of 32 inmates, so by calculation it would be 8 out of 32 inmates in our dorm. Each dorm that they overfill is 8 out of 32 would be over-detained. I was one of them, okay? By obvious calculations. But I had these notes, and they're not in any great order. I can mix them up a little bit more. Got a little piece of paper that I didn't write on. I got, a milk carton that I didn't even write on. I got a lot of them. I would separate the inner portion. This would be the plastic portion. I'd open up the milk carton, flatten it out, let it dry. You got to let it dry a little bit, and then start peeling away until I had this thin paper, which can also be a little bit of a note paper, more of a temporary note because it bends. This is the note paper that can go on the wall. This stuff is more likely to fall down off the wall when you use toothpaste. But I would peel them, and then this could be a better hard copy for writing. So my biggest challenge was keeping up with having enough pens, enough things to write with, because I could take other guys' milk cartons from the trash. A lot of times I'd be digging in the trash, taking milk cartons to peel them later and write notes on them. So I got a lot of notes here, and I'll start at the top. All right, mixing and matching like it's a card game. I don't know, it's just a lump of information here. All right, so pre-class packets. Let me turn this around. So this is important. Pre-class packets. So the inmates are getting these. Let's see. They are called the rap sheets. inmates tend to get rap sheets, okay, and there's some kind of law or rule that says that they're not supposed to be getting rap sheets, and they are. They're supposed to only be able. The LAC, the Louisiana Administrative Code, said that inmates are only allowed to make copies as they see fit of the rap sheet, but they're not allowed to have a copy of the rap sheet. But everybody with DOC numbers is getting a rap sheet. Sometimes it could take a couple of months to get. It could take a long time for some people. But according to this, the rap sheet is only an element of the pre-class packet. I try to tell a couple people, but nobody's going to listen to me, and especially inmates. They're more excited about just seeing their rap sheet. But the rap sheet is more is just one element of it. I would be asking for my pre-class packets. And class is short for classification. Pre-classification, how they classify you in jail. So it'd be basic info and interview for local jail facilities form. I haven't seen any of this from the guards. They don't seem to know about it. They don't know about much when it comes to talking to inmates. Credit for the Department of Corrections, Department of Safety and Corrections. My commitment form. Let me see my commitment form. I asked Captain Glover for that one day. Bill of information is the arguments that the prosecutor makes early on in your case before trial, so they'll apply the law to the facts, but very loosely, especially with city courts. Uniform commitment order, the UCO. Where's my UCO? I don't even think Judge Barber or Judge Ousley wrote that. Instead, what Miss Davis of the records department gave me was the minutes from my trial and then my convictions on those two separate dates. They didn't write a UCO, and the state Supreme Court is trying to encourage the judges to make out UCOs that have more detailed information specific for the jail's use than the minutes. The minutes will mention other information that the jail doesn't need. So it's to consolidate the proper information together, but they're not following it because, you know how judges are. Judges set their own precedent. It don't matter other cases that are solved and how they're decided. Even the state Supreme Court doesn't seem to be important to these city judges. That's the power of the Napoleonic law. Even at the level of a limited jurisdiction city judge, they don't have to follow the state Supreme Court as strictly as a common law judge. So it's really sad how that works. It has to make sense to the city judge, and if it don't, then they're not going to follow it. That's the deal with case law in Louisiana, the only state that follows this prescription period, Napoleonic law, run out of time, run out of rights type of style of judicial system. Let's see, past the UCO, we got the rap sheet, which every inmate gets with photo state ID. I've looked at a couple of rap sheets. It's their personal information, but some will share it. Some will just say, "Here, look at this. Does this make sense to you?" The CAD, are they using the old law or the new law? Are they using the old act or the new act? Is my time being processed properly under the proper act? There's a lot of acts that change the laws going back, to the 1800s. But, even just a couple of years, a lot can change between the acts. And they want to make sure that, when you're charged, that it's that year, that's the proper act, because it could change the next year. ATN from the fingerprints. I'm not sure. Arrest tracking number is the ATN conviction. And this pre-class packet was what I copied off of the Humphrey v. LeBlanc. They said this is the standard. This is supposed to be the standard that for inmates' information, but it doesn't always get arranged together properly. And I can go into the detail of that later. Let's see. Fingerprints for the conviction, disposition of the sentence from the auto fingerprint ID, and then the Department of Corrections and acknowledgments and signature statements signed by the inmates. All right, that's the pre-class packet. So you got that going, and that's more than just your rap sheet. And I don't know how the jail staff would respond to if an inmate asked for their pre-class packet, and saying that, okay, I got my rap sheet, but where's the rest? And they'll probably say, well, you don't get that. And I'm like, well, the law says I'm not even allowed to have a copy of the rap sheet, because I mean, what could happen if the inmate, like me, gets ejected from his dorm because all the other inmates turn against him about the smoking issue. I lost my DD form 240, DD 240. Is it 240? I don't know why I keep forgetting that. I lost my military discharge papers because of the ejection from L1. And I mean, what if it was a rap sheet? I told them this is my military paperwork that I was given that was in my locker that I no longer have because you ejected me so forcefully. What if it was a rap sheet? I don't think they'd care about that either. The way that if they're not caring about my military records, and that's what happens when they give you the copy of the rap sheet. You could lose it in a raid. You could lose it in an ejection. All right, moving on. All right, there were a couple other cases, of course, for over-detention, but let's just say that Humphrey v. LeBlanc is the most recent, significant, most highly gone over with testimony and studies, and they refer back to old over-detention cases. That's what you'll see when you study case laws, is the judges like to refer back to the most recent, previous stuff. And this was pretty recent. Shiro identified the following deficiencies. Secretary LeBlanc failed to adequately define and address DOC's responsibility. Let me just read it as we go here. DOC's responsibilities to release all the people in its custody on time. B. Secretary LeBlanc has never tried to secure commitment papers directly from the clerks of court the same day as sentencing by email. C. Secretary LeBlanc could have picked up the commitment papers directly from the jail but failed to do so. D. Secretary LeBlanc's strategic plan for DOC does not address over-detention. E. Secretary LeBlanc exaggerates any differences that the Louisiana DOC and other state DOC may have. And I find that interesting. Exaggerates the differences. Like, they're just too different, so Louisiana is not going to listen to what other states have to say. And Shiro is from like Illinois or Colorado or something, is from a different state, looking at the process, how Louisiana processes old inmates. All right, this is another set of notes. The Department of Public Safety and Corrections, if immediate released offenders are released within 2 days of the DPSC receiving the paperwork, the pre-class employees must create a case narrative to explain the problem encountered during the time computation process. I asked multiple times the records department, Miss Davis, to give me a case narrative of why I'm being over-detained. I started that on November 4th, and then it became more clear after November 30th, and they're not even going to acknowledge that there's a need for a case narrative. It's like that's the beauty of prescription period. When the time runs out, your rights run out, and they just kind of like assume that your rights run out, and they skip over the part where the time runs out. You're right. They make up all kinds of reasons for your rights to run out, that are in the spirit of the prescription period. Time runs out, rights run out. That's ridiculous. LDOC, Louisiana Department of Corrections, maintains a time-consuming process for calculating release dates, which includes both manual calculations and automated processes using an antiquated data management system. It lacks standardized training and accountability process to ensure its staff have the ability to make sentencing computations accurately. So the LDOC, they're talking about how there's using old and new processes for calculations, when all they have to do is plug this into the ChatGPT. Pretty much all the information for each inmate, you just easily plug it in and get quicker and more accurate calculations. They're phoning, they're using faxes, they're using emails. Sometimes there's a mix of management on paper. Who know? Imagine the records department just using a paper and pen to calculate my release dates, and that's why they totally skipped that 26 days of credit from 2022. They calculated my release date as just a hard number, not even seeing. Okay, they didn't even see my 26 days credits from previous, and that just shows how bad they are. They miss things, that's just me. They're missing major things that hold inmates in for 6 months sometimes. Some inmates have talked about having to stay an extra 6 months because they didn't get credit for something. All right, and the average is like a month, and that's the average. So these 6-month guys are helping bring up the statistics with the guys that don't stay in quite as long. All right, so what's the next thing here? The case of Buccicio. I think this is another case in Louisiana. Let's just read it, make sure. All right, and I wrote down the LexisNexis number here, 185604. If you have a Lexis account, they have specific numbers to help you find it. But I mean, Humphrey v. LeBlanc gets you there, 2025. As he had done in prior over-detention cases, LeBlanc argues that B has not pleaded facts establishing a pattern of very similar constitutional violations, and that his allegations are too general to support deliberate indifference in this case. And then we have is the district courts in the Middle District of Louisiana, the federal courts, not on the same process that would take it to the state Supreme Court of Louisiana. We have rejected these arguments, holding that the standard for deliberate indifference requires only a pattern of similar constitutional violations by untrained employees rather than an exact duplication. So I find it interesting how you got to be like exact. Like it has to be like the same person in the same place. It has to happen twice exactly for it to count. And that's the crazy arguments that Louisiana will make. They are grabbing at straws or strings and really they really play the game, because I mean these are the people who are trained from early childhood that when time runs out, your rights run out. Okay, these people don't think for themselves. They just go on this culture of time, and of course all the other things. It has to be exactly similar as well. And I think also they don't even if they're not even taking in what other states are doing and just saying it's too crazy, it doesn't align with how they do things in Louisiana, how Montana does things, how California does things. That's not the Louisiana way. Well, I also think they would follow the same lines as in the 1800s during the slave laws. They'll probably look at that and say, oh, that's not us. That was old time Louisiana. That's not us now. That's not exact. But it was. All right, so the next idea here that I copied off of this case. Plaintiffs claim that the evidence shows that LeBlanc and the DOC learned that thousands of DOC inmates are held past the release dates each year. That's number one. Number two, failed to set a goal of fixing the problem. Number three, did not take the steps necessary to fix the problem. 4, refused help when offered. 5, never developed an action plan the secretary promised. So other states trying to help Louisiana are too crazy, have too crazy of a system, and Louisiana just, because it's too crazy of a system, Louisiana's refusing help and just continuing to screw up people's lives, causing a lot of strife in the families by administrative problems. All right, this isn't exactly a judicial problem, but it keeps falling into judicial's hands, saying, "Yeah, we see the problem. We see the problem. Here's more testimony. Here's more evidence. We're ruling against you as an administration. You're making mistake after mistake after mistake after mistake after mistake, continuing. Yet you're refusing help. You're not firing people. You're not making changes yourself. You're refusing help. Just all of that because Louisiana is being too stubborn. All right, it's a stubborn culture, holding on to these values and causing just continually to this day, as it's happening right now, more problems. What are they going to do about this court case? Probably nothing, right? Without outside change, which had to happen during the Civil War too. Plaintiffs say that the problem was not fixed but institutionalized. So that's the plaintiff's argument. They say that the over-detention is institutionalized now. And I just want to, maybe I'll just end this with a thought from Captain Glover when we had to actually do our beds one day for an inspection from the higher ups. What's that company called again? I'll think of it later. But somebody didn't like that he had to make his bed or something, and Captain Glover said, "You're institutionalized. You're in an institution." Well, if that's so, this institution that we're at doesn't allow visitors. We're institutionalized to 5 minutes of phone call use per week for free. No video calls, no visitation, no reentry programs, no training programs. No, barely any outside activities. That's institutionalized. The library is 80% Bibles. All right, they used to have before the company moved in. It had more of a selection for books for the library. So no reading material. Lots of dope smoking. Okay, lots of fights. Poor food, poor nutrition. It seems like the nutrition is for somebody who's 150 pounds more than that anything. So somebody who weighs less than 150 pounds might actually gain weight off of this this diet. That's being institutionalized at the Natchitoches Correction Center